Good afternoon. The time is now 2:58 p.m. We will be starting the broadcast, English Learners and the Law, in 2 minutes. Please stay tuned. Good afternoon, everyone. Thank you for joining me for this month's Special Topics in English Learner Program monthly webinar. The topic this month is English Learners and the Law. I am glad that you are joining me this month for another webinar on special topics pertaining to the education of English learners. Today's presentation was born out of my realization that when I went through my ESOL degree program, I was taught American education history, but I was not taught the history of English learner education in this country. And it wasn't until later that I attended law school, and in that experience I was exposed to the history and legal battles that helped develop the congressional framework we know today as best practices in EL programming. If you had a similar experience to me and did not learn the history of English learner programming as we know it today, and the legal precedent that leads up to how we serve English learners in our schools, then this is the right broadcast for you. This month's presentation will provide an overview of some of the major court cases and federal legislation that have shaped current EL programming in public schools in the United States. Specifically, I'll be covering why public schools identify English learners, provide a high-quality language instructional education program, assess EL language growth, and educate ELs in inclusive settings. You'll see the second bullet there has a very long-term language instruction educational program. Throughout this broadcast, I'll just use EL program instead. So my objectives today are for you to receive an overview of the landmark court cases and legislation that pave the way for EL rights. Learn the key issues, historical content, and rulings behind each legal action that we cover, and to understand the outcomes of the legal cases that are germane to the work of English learner points of contact, as well as EL specialists and all educators who support English learners. I'm going to run you through an assessment. So you're going to take a pretest. You'll be using the chat box to record your answers, and this is a no judgment zone, but the answers will be related to how well you know the history behind EL programming in this country. In this assessment, The Department of Justice, U.S. Department of Justice complaints that I'm profiling are real. So your instructions for this quiz. You're going to read the following 3 legal issues and then use the chat box to type your answer, selecting the legal case that most closely applies to each issue. Let's take a look at the first one, and then I'll repeat the instructions. Issue 1. You'll see at the bottom of the slide, you're provided with a link to the U.S. Department of Justice repository of complaints and settlements. So you can actually look up this case yourself. The history is that District A is alleged to have provided English learners an inadequate EL program, specifically with respect to providing ELs with sufficient language services and adequate access to grade level curricula. The issue that the Department of Justice had to decide on was whether the district was properly identifying and placing its ELs into language programs that adequately served secondary EL students. Now the question for you is, which legal case is the U.S. Department of Justice likely to cite to in its action against the district? Is it likely to cite to Mendez versus Westminster School District, selection A, or B, Lau versus Nichols? You can type your answer, either A or B, into the chat box. And it's okay to take a guess. Okay, thanks for participating. Just letting you know, I'm going to save the answers for the end, but still do type in your answers as we go through this pretest. We'll be covering the cases that I'm mentioning in greater detail, so you'll know what they're about and then get a sense of whether your answers are correct or not. All right, issue 2. District B is alleged to have established barriers for certain students to enroll in and register for school because of their or their parents' national origin or immigration status. So this is a real complaint from 2014. The issue the Department of Justice had to decide on was whether the district may bar families from enrolling their child if they cannot produce a document to verify their residency in the United States. Which legal case is the Department of Justice most likely to cite to in its action against District B? Is it A, Plyler v. Doe, or B, Lau v. Nichols? Go ahead and use the question feature or the chat box to type in your answer. All right, moving on to issue 3. This is the last one for our pretest. Background is that District C is alleged to have used educational technicians, or what we know as paraprofessionals, to perform long-term or unsupervised EL instruction in lieu of hiring and retaining an adequate number of certified EL teachers. The issue at hand is whether District C was providing appropriate instruction and services to ELs, particularly among the district's large population of Somali refugees. Which legal case will most likely be cited? A, Mendez versus Westminster School District, or B, Castaneda v. Pickard? Thank you for typing in. This is the end of the pretest. The preceding issues come from real complaints, as I mentioned, and the links are provided at the bottom. So if you're interested in seeing the actual complaints and settlements, you will be getting these slides emailed to you after the webinar. The complaints you'll find on the U.S. Department of Education's Office of Civil Rights and the Department of Justice's websites are voluminous, believe it or not. So to be complacent and think there are no checks and balances in EL programming, or to think ELs and their families don't really raise grievances is faulty thinking. In the issues you just saw, you don't know the individuals who raised their voices. But now we're going to take a more intimate look at the students and families who changed EL programming in this country for English learners and for other populations of students. So here's the definition of an English learner. In our public school systems, we recognize that ELs can be ages 3 through 21. They're enrolling in elementary or secondary school. They may have been born in the US or not, but this definition includes Native Americans and Alaska Natives, or a native resident of outlying US territories that comes from an environment where a language other than English had a significant impact on their English proficiency. The students may have difficulties in speaking, reading, writing, or understanding English, and that may be a barrier for them to meet the challenging state academic standards, achieve in classrooms with English instruction, or have the opportunity to fully participate in society. And this is a federal definition. So just a little bit of background about how the legal system works in the United States. I'm taking here a top-down approach. So once a case has made it through the court system, some will go just to the local level, a local court, and some will make their way all the way up to a federal court. It's those federal rulings that have the most weight on what we do. So the federal decision or the federal ruling trickles down to the state level. And we at OSSI are a state education agency, or SEA, and we do have to mind the federal rulings. We take what we have learned from the federal ruling and deliver that information to you at the local education agency, or LEA level. If your LEA has multiple schools within it, you as an LEA or your leaders at the LEA level are required to pass that information to you at the school level. So let's say someone complains to their local court. That decision will then affect the local area, let's say the city. If a party to the case does not like the outcome of the local court decision, they can appeal that decision in their local court of appeals. And then that decision can be appealed again in federal court. That decision can then be appealed one more time by the highest court in the land, the US Supreme Court. The cases I'm going to share to you now all ended up influencing public school systems across the state where they originated, whether they made it to the US Supreme Court or not, interestingly enough. So some of these are Supreme Court cases, and some of them, the cases had influence just because of the nature of the case at the state level. So now I'm going to explain the major cases one by one. And the first is Mendez versus Westminster School District. Here's the synopsis. A tenant farmer of Mexican descent, Gonzalo Mendez, moves his wife and child to the mostly white town of Westminster in Orange County, California. They take up a farm recently vacated by the Munemitsu family, who had been forced onto a Japanese internment camp. Gonzalo Mendez's children need to go to school. For Gonzalo and his family and other similarly situated families, going to school ends up being a very big deal, as we shall soon see. It's such a big deal, in fact, that their legal saga over school enrollment ends up in the LA Times. And you can see on the screen part of the Los Angeles Times article from 1946. The ensuing court case even makes it onto a September 2007 US postage stamp, and that appears on the left side of the screen. The time is the mid-1940s. The Mendezes were unable to enroll their daughter Sylvia and her siblings in school that particular day, so Gonzalo's sister takes them to the school along with her own girls who also need to be enrolled. Now, the school denies Gonzalo's children, but will enroll their cousins. Their cousins, in fact, have light skin, honey blonde hair, and a French surname. You can look up this case and you'll indeed likely find artifacts so that you can see the relatives and the differences in appearance. So the cousins have a different appearance and a French surname. Sylvia's aunt, however, refuses to enroll any of the children. Gonzalo then tries speaking to the school and the school board, but receives the same message. The schools are for whites only. He can enroll his children in the local Mexican school, establishments California had created statewide for students of Mexican descent. Segregation of schools in Orange County, California began in 1913. It's over 100 years ago. In 1919, 100 years ago, the local school district began placing children of Mexican descent in separate Mexican schools, typically operating under subpar conditions. Parents of Mexican descent attempting to enroll their children in Anglo-serving schools, and that was the term at the time, Anglo. Those parents of Mexican descent were refused. And by 1933, 15 of the county's 44 elementary schools were Mexican schools. This mirrored school practices in the southwest of the United States and nationwide segregation of housing and public facilities. So the family here won in Superior Court, their local court, but the local school district in Orange County appealed. And then there was a trial with testimony from students and experts. Experts testified to the social emotional harm and barriers to developing English with that social emotional harm. So they said, even if the facilities are equal, the students' placement in the facilities would lead to harm. The judge's decision recognized discrimination based on national origin and infringement of the students' civil rights. Thurgood Marshall, who at the time was an NAACP attorney, helped file an amicus brief along with other civil rights organizations, and Mendez, the plaintiffs, eventually won. So you may recognize the name Thurgood Marshall. He was an attorney for the organization known as the National Advancement Association for the Advancement of Colored People. And we have a school named after him here in DC. So there are a lot of connections to be made here. This is a case in which California, the first state to do so, ended school segregation in June 1947, and that was 8 years before Brown versus Board of Education. The segregation of housing, public facilities, and public establishments starts to crumble at this time, and school segregation for Native American children and children of Asian descent is outlawed. So this had rippling effects across the country for multiple populations of students and for multiple populations, non-white populations in public housing and other public facilities. So this was actually a big deal. The ruling influenced the outcome of Brown versus Board of Education, as you can see in the Danville Bee, this newspaper here. This paper is a newspaper out of my father's mother's hometown. I wasn't trying to look for it, it just appeared while I was doing the research. People of color in public schools today are the beneficiaries of the Mendez versus Westminster ruling. Now, Brown versus Board of Education found that separate was not equal. Segregation of public schools violated the law and was unconstitutional. Thurgood Marshall, you'll remember from this case, successfully argued as the chief legal counsel in the case before the Supreme Court. So Thurgood Marshall, argued in two cases. This case, Mendez versus Westminster, and after Mendez, he rose to the level of chief legal counsel for the NAACP, and he argued before the Supreme Court in Brown versus Board of Education. So I wanted to share a picture of Sylvia Mendez as a child. You'll see her seated at a piano to the left. And on the right, there's a picture of Ms. Mendez receiving the 2010 Medal of Freedom from President Barack Obama in 2011. And sometimes we think of the civil rights movement as a black and white issue, but there are unsung heroes in our legal history, including Native Americans, Asian Pacific Islanders, and Latino and Latina heroes who paved the way for the civil rights movement of the 1960s, and who have influence over our local and federal laws today. It's interesting to share the background of these cases with students that you may have, to show them that people who may in fact share a similar background asserted their rights in the face of seemingly unsurmountable obstacles. The next case is Lau versus Nichols, a case that was decided in 1974. So let's set the stage for you. The time is 1971. Public schools in San Francisco, California are integrated, not segregated, but a large number of students of Chinese descent in the school system did not speak English. Less than half of those students were placed in courses to develop their English. Kinmon Lau, was a student who did not receive English language instruction. It is Kinney who brings this case against the San Francisco Unified School District. And here's a picture of students of Chinese descent in front of a school in San Francisco. This picture is often associated with the Lau versus Nichols case. Kinney claimed the district's failure to provide him and similarly situated students English language instruction denied them meaningful opportunity to participate in public school. Kinney further claimed this violated his and the other students' rights under the Civil Rights Act of 1964. And the act bans discrimination based on race, color, or national origin in many arenas. One such arena is a program receiving federal funds, like a public school, and a program which implements the regulations of the Department of Education, which many public schools do. The district court or the local court in this case sided with the school district, not with Kinney. So Kinney appealed, but the appeal failed. And Kinney took the case up to the United States Supreme Court. Now, when I mentioned Kinney's name, just like with the Mendez case before, Kinney and his family had the support of other students who were similarly situated, and their families and legal team. But I'm going to use the name Kinney because he is prominently associated with his own case. So the case went all the way up to the Supreme Court. The reason his local court sided with the school district was because it found that 2,856 EL students of Chinese ancestry, out of that number, so out of nearly 3,000, only 1,000 were in the Chinese special instruction classes. So it seemed like the majority of students weren't so affected. But evidence that was later compiled and discovered included a report by the Human Rights Commission of San Francisco, and the evidence showed that in April 1973, actually over 3,000 ELs, actually 3,457 English learners of Chinese ancestry existed in the school district, and only half were receiving English instruction. So the local courts were relying on erroneous information. And that's one reason this course was successful at the Supreme Court level. Another piece of evidence that the Supreme Court considered was the California Education Code. And in Section 7 of the code, it states that English shall be the basic language of instruction of all schools. All students must demonstrate a mastery of English in order to graduate. And bilingual instruction is allowed as long as it does not interfere with the regular instruction of all pupils in the English language. So the Supreme Court decided that where an inability to speak and understand the English language excludes national origin minority group children from effectively participating in the school district's educational program, the school district must take steps to address the language needs of the students in order to open its instructional program to these students. You can see here some quotes from the judge's opinion or the judge's decision. And they're pretty strong statements. If you read them in order, that's a very logical sequence. The judges also agreed that tracking students is not okay if it's going to lead to an educational dead end. Also factoring into their decision was the fact that in this country, the taxpayers are of all races, and their tax money funds public institutions. So it is not okay for public institutions to encourage racial discrimination. The outcomes of the Lau case also led to the development of what's known as the Lau remedies, which are a set of guidelines for assessing compliance with the Lau case and providing educational services. Most importantly, the right to instruction in a language comprehensible to English learners. So as I mentioned, this case made its way up to the Supreme Court, and the decisions from the Supreme Court funnel down to us at the state education agency level. We funnel them down to you at the local education agency level. And if you have multiple campuses at your LEA, you must also funnel that information to the schools. So all of you who are at a school or LEA would need to make sure that your EL program is in compliance in accordance with the law remedies. A further definition of EL program placement came with the next case, Castaneda versus Pickard. Here's a comic that is sometimes associated with the theme of the case. And as you'll see here, the gentleman with the mustache says hello to the other man. The other man says, "Why don't you want to learn English?" The gentleman replies, "Yes, I want to learn English." And the second man says, "That's it. I'm declaring English as the official language." The first gentleman says, "But sir, I want to learn English." And the second man says, "Ballots and store signs will all be in English." So the man with the mustache has his son and says to his son, "Son, teach me how one says, I want to learn English. How do they say it in English?" And the second man says, "Oh, that reminds me, bilingual education should be ended." Well, the next statement is, "I want to learn English." But the second man throws up his hands and says, "I don't understand," in Spanish. And you'll see how the comic matches the case as we explore the case further. So I'll set the scene for you. Roy and Flo Castaneda are pillars of their community in Texas, and they're known for responding to the injustices imposed upon Mexican Americans in the local school system. Roy owned a number of local Quick Marts in their town. He was very observant of the racial dynamics locally, and he had political aspirations and was also a member of the local school board. He freely doled out advice to a number of local parents who frequently did not speak English and were just barely making it. They used to go to his Quick Mart or one of his Quick Marts, and in the back of the stores, they might be able to find him in the store office, and they talked to him about their needs and what their realities were. Flo, his wife, graduated valedictorian of her high school class and got a scholarship to business school. She worked for an attorney before teaching for 35 years in the Raymondville, Texas Independent School District. So both parents were well aware of the disparities in the schools, the mistreatment of Mexican American children, and the blatant discrimination that occurred in the schools, including segregation. The school district on paper had a bilingual education program, but in reality, they were not hiring lead or certified bilingual teachers for their bilingual education program. So the bilingual program was actually staffed primarily with monolingual English speakers. Occasionally, there may be a Spanish-speaking teaching assistant leading the class, but the assistants were not certified teachers. So the bilingual program, which was designed to develop both mastery of English and content, was a failure in its execution. Here's a fun fact for you. The lead attorney in this case was a Texan, a self-described Anglo, who was a product of segregated schools. But despite that background, he took on the case willingly. In 1981, the U.S. Court of Appeals for the Fifth Circuit stated that a three-pronged test must be used to ensure that bilingual or English language acquisition programs were meeting students' educational rights. As a result of this ruling, English language acquisition programs, or EL programs, are required to adhere to the three-prong test. And the three prongs are: 1, the program is based on sound educational theory; 2, the program is effectively implemented with sufficient resources; and 3, the program is evaluated and proven to be effective. At the bottom of this slide, if you're interested in taking a look at the Castaneda family interview, along with some statements by the lead attorney, you can see the Meshpedia clip there. It's a pretty moving history narrated by the players in this court case themselves. As a result of the ruling, English language acquisition programs are required to meet the three prongs, which is now known as the Castaneda test, and you see those three prongs there on the screen. There's another major court case that I wanted to share with you. Let me just get my bearings here. All right, let's look at Plyler versus Doe, which was decided in 1982. Here we see an artist's rendering of a fictitious school named after the Tyler Independent School District Superintendent, James Plyler, out of Texas. In the artwork, you can see people peering out of the school, and presumably a newcomer family looking in as they approach the school. Do you see any differences in the people peering out of the school and the people peering into the school? And what do you notice about the school building itself? So the background for this court case is the undocumented students who filed this complaint relied on the Equal Protection Clause of the 14th Amendment, and that is in the U.S. Constitution. The Equal Protection Clause provides that no state shall deny to any person within its jurisdiction the equal protection of the laws. Person in that provision includes someone who is undocumented. So the Constitution says that no state shall deny to any person, even undocumented person, within its jurisdiction the equal protection of the laws. And jurisdiction here means anywhere in the United States, even if the person entered the country illegally. So the undocumented students who lived in Smith County, Texas, claimed they were denied an education within the Tyler Independent School District, run by then Superintendent James Plyler. The school district tried to defend itself once the case went to court. The school district argued the education of an increasing number of immigrant Mexicans would strain the state's finances. In addition, they argued the quality of education at the schools would be hampered by trying to respond to their special educational needs. At the time, in 1975, the Texas state legislature passed a law that would withhold state funds from being used for children who were undocumented immigrants. And that law further authorized local school districts to deny these same children access to public schools unless they paid an annual tuition of $1,000. In some instances, the law was used to bar undocumented students from enrolling altogether. The district court found the following matters of fact. 1, there was an increase of students in the district, an increase of legal residents. The rise in illegal students was comparatively small. 2, keeping undocumented students out of the schools would save money, but just a little bit. And 3, keeping the undocumented students out of the schools was not guaranteed to improve the quality of education in the school district. So the courts did side with the students, but the school district appealed and appealed again, all the way up to the Supreme Court, trying to pursue 2 wobbly legs in its case. One leg wobbled over the definition of person. Was an illegal alien a person? The other leg wobbled over the word jurisdiction. Was a person who crossed the US border illegally within the state's jurisdiction? And courts consistently found that yes, a person who could not prove their legal residency was still a person. And yes, a person who crossed the border illegally was still within the state's jurisdiction. So ultimately, the US Supreme Court ruled in favor of the students, and the court picked up on a statement made in the lower courts. So the Supreme Court is all the way up at the top, and the lower courts are the courts where the case started in the local, not federal. All right, so the statement that the court picked up on was that today's illegal immigrant would likely be tomorrow's legal immigrant. Today's illegal immigrant would likely be tomorrow's legal immigrant. And without an education, these undocumented children, already disadvantaged as a result of poverty, lack of English-speaking ability, and undeniable racial prejudices, will become permanently locked into the lowest socioeconomic class. And there on the screen, you'll see the ruling of the Supreme Court. At the bottom of the slide, the decision was, it is unconstitutional to deny a free elementary and secondary public education to children living in the US, regardless of the immigration status of the student or their parents. So as a consequence, the case declared that immigrant children did have access as residents to citizenship rights protections under the 14th Amendment of the Constitution. Okay, so those are 4 of the major court cases that inform the work that we do today to support English learners. What all of that background means for what we do today is that the federal law reaches down to us in so much as what we need to do to provide services to English learners. And those cases now inform English learner identification, parental notification, EL's participation in annual state assessments, EL participation in the Annual English Language Proficiency Assessment, which is WEDA here, and requirements that LEAs communicate with parents in an understandable and uniform format, and that to the extent practicable, they communicate with families in a language that the parents can understand. Let's see how much you remembered from the profile of those 4 cases. Can you name this case? Right, you can get back to the question box or the chat box, and this is an unconstructed response. So I'm not giving you an A, B, or C, or a 1, 2, or 3. You just have to see if you can remember the name of the case. Which case discussed the elements of a 3-pronged test? The test that requires EL programs to be based on sound educational research implemented with adequate commitment and resources, and to be evaluated and proven effective. If you remember the name, go ahead and type it in. Interestingly enough, it's the same case that shaped the requirements that Title III schools, which are schools that receive funding through Title III, have to show how their EL program will address EL's language development and academic development needs using a scientifically based rationale. And those Title III schools have to show how their EL program will be properly resourced and how it will evaluate the EL program to ensure its success. Let's see if anybody was able to identify this case. All right. Yes, it was Castaneda. Castaneda versus Pickard. Good job. So here you have some supports or resources that come from the federal government. Almost all of these come from the U.S. Department of Education. If you want to learn more about the Elementary and Secondary Education Act, it's rather large, but it's been reauthorized and now called ESSA, the Every Student Succeeds Act. That's the first link. The Department of Education also houses an Office of English Language Acquisition, also known as OELA. And that is a little more information about them, their resources, and what they do is in the second link. The U.S. Department of Education's Office of Civil Rights has a lot of material on what constitutes an EL program. You can also find complaints, known as OCR complaints, that were filed against school and school district EL programs. The Office of Civil Rights within the Department of Education has a policy update, which is the second to last link. And this is a statement on schools' obligations toward national origin minority students with limited English proficiency. And at the very bottom is the repository of Department of Justice cases that are related to education. I think they are categorized by topic. So you can find cases related to language acquisition in one category. Otherwise, they're not so organized, but you can specifically search for cases related to language acquisition. At the beginning of this webinar, you went through a pre-assessment to see how well you were informed or knew about cases that inform the work we do today. You may have had the right answers, you may have had the wrong answers, you may not have known what the answers were, or you may have had an answer and didn't know if it was right or wrong. Here's your opportunity to now show what you know and see what you have gotten out of this presentation. We're going to do a post-test now that you've reviewed some of the major legal cases. Reread the following legal issues, and then once again select the legal case that most closely applies to each one. So you'll remember here, School District A alleged to have provided ELs an inadequate EL program, which meant in this case ELs did not have sufficient language services, nor did they have adequate access to grade level curricula. Which legal case is the Department of Justice most likely to cite to? Mendez versus Westminster School District or Lau versus Nichols? Remember, Mendez was the case out of California. Orange County, California, and Lau was the case out of San Francisco. Go ahead and use the question or chat box. Let's see what you remember. And the answers are coming in. And the correct answer is B, Lau versus Nichols. That was a case where Kinney Lau was in school, so he wasn't denied access to school. He was in school, but there were no services for him to learn English, and the curricula was in English, and so there was no way for him to be successful and access the grade level curricula because he really didn't know English. So he needed proper support. This issue that you see here, I'm calling School District A, was settled by the Department of Justice not that long ago, the end of May 2019. All right, issue 2, so you'll recall District B is alleged to have put up barriers for certain students to enroll in and register for school because of the students or the students' parents' national origin or immigration status. So was it okay for that district to bar families from enrolling their child if they didn't have documentation to verify their residency in the US? In answering this question, which legal case that we reviewed is the Department of Justice most likely to cite to? Mendez or Plyler? Again, Mendez was out of Orange County, California. It was the first school district, the first case we looked at, and Plyler was out of Texas. It was the last case we looked at. The correct answer is Plyler versus Doe. And that's the case where someone participating in the webinar asked if the artwork showed Guadalupe. And in that case, similar to this complaint here, students were initially barred from enrolling because their parents couldn't produce residency documents, and were also told, yes, they could attend school if they paid $1,000. So they were not accessing free public education. 3, and this is the last one. You'll recall District C, which is alleged to have used paraprofessionals to perform long-term or unsupervised EL instruction instead of having hired and retained an adequate number of certified EL teachers. So was the district providing appropriate instruction and services to ELs? In this district, there were a large population of Somali refugees trying to get an education. Is the Department of Justice most likely to cite to Mendez or Castaneda? Castaneda is another case out of Texas with that 3-pronged test. Let's see what you're answering. And the answer is yes, Castaneda. Nice. All right, I hope this presentation has been valuable and informative. I want to take just a couple of moments before we wrap up to share the exciting lineup of opportunities that we have for you. The Division of Teaching and Learning is doing a little tweeting. This month, our tweets are centered around teacher leader stories, and we encourage you to share your teacher leader story this month. We're promoting stories about teachers who go above and beyond in their dedication to DC students, families, and schools. So if you want to send your teacher leader story tweet, you can tag @AussieDC and use the hashtag teacher leader story. We're going to retweet the great stories we hear through the month of September. Also, if you are an EL point of contact, an EL POC, and you attended this year's Start of School Summit, please complete the Start of School campaign feedback survey. There's a link on this slide, so when you get the slides via email, please click on it, and the link is valid through September 20th. We want to hear from you, and your thoughts will help us plan for next year's Start of School Summit. We are here to support you. We're OSSE's Division of Teaching and Learning, affectionately known as TAL. We have professional learning and technical support for you. We support with a wide range of topics, and you'll see we have a growing list of staff who support in a variety of content areas and specialty areas. Please reach out to us. If we don't hear from you, we can't assist. Some resources that pertain to English learners, our policies and procedures document is the big blue link at the top. It's what you need to know to put together and maintain an EL program. It's available for download at that link, which is also on OSSE's EL webpage. Also within that large document, in Appendix A, is the Quality Programs for English Learners School Readiness Reflection Tool. It is a very comprehensive checklist that lets you determine how well-rounded your EL program is, and also helps you to plan for filling in gaps that you may have. It's now available as an editable form, so you can download it and fill it in. The link is now there for you. OSSE has an EL webpage full of many resources, and that page is growing. I invite you to take a look there at the third link, and reach out to the multilingual learner support team. We provide support, technical assistance, and we'd love to hear from you. That's me, Anika Harris, Dr. Jennifer Norton, the program manager, and our multilingual specialist, Santiago Sanchez. Got trigger finger here. Some of our upcoming events are listed here. If you want to know more about the events and subscribe to a news feed that will forward you events as they come along, click that very top link. We have the new Teaching and Learning PD Bulletin, and we'd love for you to sign up and stay abreast of all that we have to offer. I will be leading once again the English Language Acquisition Workshop Series. It's a 3-part series. Join 1, join 2, or join all 3 workshops. The first one is on September 23rd here at OSSE. The registration link is there for you. There's also an invitation for you educators to join the 2020 State Title III Advisory Committee, also known as STAC, where we work through and policies that drive what you do for English learners. That application closes early October. There's an upcoming webinar, also early October, English Learners and the STAR Framework. So you can learn more about the STAR Framework. And we will be repeating our successful cohort series, What Teachers Need to Know About Teaching English Learners, which is developed for teachers who are new to teaching English learners, whether you're a brand new content or special education teacher, or a related service provider, or you are a new EL specialist. That's a 4-part series. You'll be part of a fun cohort, and hope to see lots of you there. Next month's webinar is on accommodations for English learners. We'll demystify what those accommodations are, share with you where you can find the accommodations and how to apply them. It's a very important topic. That will be next. The webinars are always the second Thursday of the month from 3 to 4 p.m. So the date of the accommodations webinar is Thursday, October 10th at 3. There's a new workshop called Supporting English Learners in the Four Language Domains, which is an outgrowth of last year's monthly webinars. So not only will you be understanding the importance of the four language domains, but also getting some hands-on activities to use with your students to support their growth in listening, speaking, reading, and writing. And the potential of biliteracy is open to those of you who work in dual language programs, and the link for you to register is at the bottom of the slide. Again, if you have questions about various aspects of supporting students, our professional development team is here to support you. Just reach out to us via email. You can find more trainings in the LEA Look Forward, and there's a little blurb here about how to sign up for that, how to find out about the Aussie events calendar. And I thank you very much for joining. Have a great rest of the day, and I look forward to your participation in next month's monthly webinar.